If you have an immigration case in progress, then you know how much effort and patience it takes to complete your paperwork and fulfill all the requirements. And like many immigrants, you know how it would feel to receive that dreadful and horrifying notice of intent to deny. But fear not, because a notice of intent to deny, or NOID, is not a final decision. It usually provides you with an opportunity to address any issues with your application before an actual denial occurs. Whether you're applying for a green card, U.S. citizenship, or other immigration benefit, understanding how to respond to a NOID the right way can significantly impact your case's outcome. So in this video, I'll walk you through what a NOID is, why you might receive one, and most importantly, how to respond to it and correct course. So, what is a notice of intent to deny? A NOID is a formal notice from USCIS indicating that they are considering denying your immigration application. Unlike a straight denial, a NOID gives you instructions and a time frame to address any concerns or deficiencies that USCIS has identified. You typically have 30 days to respond with additional evidence or clarification. Failing to respond or not addressing the issues adequately could result in a denial of your application. What should you do if you receive a NOID? The first thing to remember is not to panic. A NOID is not the end of your case, but it does require prompt and careful action. Here's what you can do. First, read the NOID carefully to understand why USCIS intends to deny your application. The NOID will outline the specific issues USCIS found with your application, whether it's insufficient documentation, inconsistencies, or legal concerns. Pay close attention to the response deadline and the evidence requested. Second, you should gather some additional evidence. As soon as you understand the issues raised in the NOID, start collecting relevant evidence needed to resolve the concerns. This could include updated documentation, affidavits, financial records, or proof of relationships. Make sure the evidence is organized and directly addresses the concerns outlined by USCIS. Third, make sure to respond on time. You only have one shot to respond to a notice of intent to deny. USCIS will include in the notice what your deadline is, but typically it's 30 days. A late response will not be accepted. So ensure that your response is complete, accurate, and submitted before the deadline. I would recommend using a reliable delivery method, such as certified mail, to confirm that USCIS received your response. And lastly, consult an immigration attorney. Responding to a NOID can be complex, and it's super important to get it right. Consulting with an experienced immigration attorney can help you craft a strong response that addresses USCIS's concerns thoroughly. It is generally recommended that an immigration attorney handle responding to your NOID. Now, before diving into how to craft your response, it's helpful to understand why USCIS might issue a NOID. So here are some of the most common reasons I've seen in my practice. One of the top reasons is that USCIS may believe that the evidence you submitted does not sufficiently prove your eligibility for the benefit you are seeking. This is common in family-based immigration cases where documentation like marriage or birth certificates or financial support documents may be missing or unclear. Also, if there are any discrepancies between the information provided in your forms, interviews, or supporting documents, USCIS may issue a NOID. This can happen if there are inconsistencies in dates, employment history, or personal details. For marriage-based green card applicants, USCIS might doubt the legitimacy of your marriage if the evidence provided is insufficient. A NOID may be issued if USCIS suspects that the marriage is not bona fide or lacks enough supporting documentation, such as joint financial accounts or photos together. Lastly, sometimes you may receive a NOID because of an administrative or an interpretive error by USCIS. For example, if you're applying for an immigration benefit, such as a green card, you need to be considered admissible. Admissibility under immigration law involves factors like past immigration violations, unlawful presence, misrepresentations, and criminal records. There are instances when USCIS incorrectly determines someone to be inadmissible. In these cases, it's useful to provide an explanation of why the individual qualifies to be admissible under immigration regulations. On the other hand, when inadmissibility is clear, the notice of intent to deny allows the individual to submit a waiver of grounds of inadmissibility. This waiver process is complex and requires proof that the inadmissibility can be forgiven. In other situations, a person may be accused of misrepresentation when there was no actual misrepresentation, and NOID gives a chance to clarify, under immigration law, why the prior statement does not constitute a misrepresentation. So, how should you respond to a NOID effectively? First, you should accurately understand the specific concerns. Each NOID will outline the reasons USCIS intends to deny your application. Make sure you address each concern directly. For instance, if USCIS questions the legitimacy of your marriage, you should provide additional evidence such as joint bank account statements, lease agreements, or photos photos documenting your relationship. Your response must include all additional evidence requested, and make sure that all evidence is clear, complete, and easy to understand. In addition to submitting new evidence, you should write a letter explaining how the additional documentation resolves the issues USCIS raised. Be organized in your letter, addressing each concern USCIS mentioned in the NOID. If there were any misunderstandings or inconsistencies in your initial submission, clarify those points here. Now, while responding to a NOID is critical, the best approach is avoid getting annoyed in the first place. Here are some tips to help you submit a strong immigration application. Remember, each application is different, but these tips apply to most cases. First, make sure to submit a complete application. It sounds straightforward, I know, but I can't tell you how many times I've seen cases denied due to incomplete forms. It's very important that you review your application to ensure that all your forms are completed correctly, signed, and submitted with the necessary supporting documentation. Incomplete forms or missing documents are one of the most common reasons USCIS sends notices of intent to deny. Second, you should provide strong evidence. Your application depends on this. Include all required documentation. If possible, go beyond the minimum requirements by providing additional supporting documents to strengthen your case. Third, prepare well for interviews. Review your application and supporting documents beforehand to ensure you can answer any questions accurately. Mock interviews are always a good way to prepare. Make the mistakes while you're in a safe space before you're in it for real. Last but not least, stay updated on USCIS changes. USCIS guidelines and policies shift frequently, so stay informed about any changes that may impact your case, especially those related to public charge rules or specific visa categories. So what happens after you submit your response? Once USCIS receives your response, they will review the additional evidence and make a final decision. If your response sufficiently addresses the issues raised, USCIS may approve your application. But if USCIS determines that your response does not resolve the concerns, your application may be denied. In this case, you may have options to appeal the decision or file a motion to reopen or reconsider your case. Now let's look at some of the most frequently asked questions about tackling notice of intent to deny. Question number 1. What's the difference between a NOID and a straight denial? A NOID gives you an opportunity to respond to and address USCIS's concerns before a denial is issued. A straight denial means a decision is final, and you may need to explore appeals or other legal options. Question number 2. Can I appeal if my immigration case is denied after a NOID? In many cases, you can either appeal against the denial or file a motion to reopen or reconsider your case. But this is where things get messy, so make sure to weigh your options carefully. Question number 3. What if I don't have enough evidence to respond to a NOID? If you're struggling to gather sufficient evidence, you may be missing something that you're not aware of. Each case varies, so you should work with an immigration attorney to weigh your options. They can help identify alternative forms of evidence that may support your case. Remember, although receiving a NOID can be stressful, it's not the end of the road. With the right approach, you can salvage your application and get the outcome you've hoped for. If you found this video helpful, please like, share, and subscribe to stay informed on what's new in immigration. Thank you for watching, and I'll see you in the next video.